Obamacare goes to court again. It is Tuesday, March 25th, and this is Now.
A make-or-break moment in healthcare, women's rights, and religious liberty.
The key argument before the Supreme Court.
A question it has never faced before. Can a business claim it has freedom of religion?
The company line, arguing that insurance policy should not have to cover certain types of birth control.
The first challenge to health care law in nearly 2 years.
Birth control is mandated under Obamacare, but they say it violates their religious beliefs.
Women take birth control as a medication for other conditions, so it is an attack on women.
The Obama administration has really defended this birth control mandate under intense political criticism.
This is the court that said that for-profit companies can have free speech rights.
This could be a slippery slope.
If they have religious rights on contraception, could it go to immunization?
If you're gay and you're going to have a wedding, then a florist or a caterer can say no because my religious beliefs allow me not to serve you.
So do 51% of the shareholders get to vote? No one is forced to take birth control. It's an individual right. This is America. This is the 21st century.
In yet another landmark case, the Supreme Court appears divided. That seems to be the takeaway today after 90 minutes of oral arguments this morning. At issue is whether two for-profit corporations, Hobby Lobby and Conestoga Wood, should have the same religious rights as individuals or religious organizations. Both companies object to the contraceptive mandate in the Affordable Care Act, but their case could have implications far beyond birth control. If a corporation has a right to religious freedom, can it object to vaccines or AIDS medication or even family leave? According to today's reports from the courtroom, those were some of the concerns of the court's liberal justices, Ginsburg, Kagan, and Sotomayor. But on the conservative side, Justice John Roberts and Sam Alito appeared to accept the idea of corporate personhood, a concept they upheld in their rulings on Citizens United. Meanwhile, Justice Breyer remained quiet, and Justice Clarence Thomas, as usual, said absolutely nothing. Once again, the decisive vote in this divided court is likely to fall on Justice Anthony Kennedy. The court is expected to reach a decision on both cases in late June. Joining me now from Washington is the president of NARAL Pro-Choice America, Ilyse Hogue, and in Los Angeles, California State Senate candidate Sandra Fluke. Ilyse, let me start with you. You were in the courtroom today, and there seem to be two issues here. One is whether corporations are entitled to religious freedoms as protected in the U.S. Constitution, and the second is whether the contraception mandate in the Affordable Care Act represents some sort of undue burden. And on that second point, I'm curious to know what you thought of the arguments, because at what point, from what I understand, Hobby Lobby actually offered its employees a plan that would have covered the very thing they are saying is an undue burden, which is coverage of the Plan B pill. What did you make of the argument on that point in particular?
I mean, let me start, Alex, by saying thank goodness for Justices Ginsburg, Sotomayor, and Kagan. I cannot imagine what it must have been like before we had any kind of gender representation on the court, because they were the only ones who were actually articulating an understanding of what's at stake for 99% of women in this country who depend on birth control at some point in our lives for some reason, be it medical or to prevent unintended pregnancies, which is also medical. You know, it really was a fascinating oral argument, and the question of whether it places an undue burden on the employers was, debated hotly, and really only a moment was spent on whether or not finding in favor of Hobby Lobby and Conestoga would place undue burden on the workers. And that is a big concern. And as this case unfolds is, if the court finds in favor of the plaintiffs, it would be the first time that corporate rights were upheld, that the idea that corporations have this, right to be this or that would be upheld at the expense of their workers, where it would quash the rights of their workers, and that would set a very, very chilling precedent.
Let me follow up on that, though. In terms of the female justices, it is great to have women on the Supreme Court, and we hear from reports that they were the most skeptical. Well, I mean, what was the sense that you got in terms of level of indignation from these three women in and around this case?
You know, I was impressed by their presentation of their questions. I was impressed by the fact that they were actually really pushing the plaintiff counsel on what does this mean? Where does it end? Today, this is about eliminating women's right to equal coverage under the health care law to our reproductive health. But what does it mean in terms of an employer who might oppose vaccines, an employer who might oppose blood transfusions? And in articulating those concerns, they were very, very clear that they understand that access to contraception is health care. It is a medicine, just like thousands of other medications out there that have not been debated in the Supreme Court or anywhere else, including Viagra, by the way. And therefore, what Obamacare has done has created equality among medical treatment for women. It's an incredibly important point, and the Justices Kagan, Sotomayor, and Ginsburg made sure that it was entered into the court record.
Sandra, Ilyse brings up a really good point about men and women and sort of mythologies around contraception, and that I don't think a lot of people know. I believe it's 58% of women have used contraception for medical medical purposes. There's also the myth making in and around Plan B, which Hobby Lobby is considering an abortive pill when in fact it is not. It is a contraceptive pill. That seems to be at the root of this as politics. Tell us more. I mean, you were involved in sort of a hurricane in and around the subject of contraception and access to contraceptive pills. How do we better explain to people that this is a fairly basic form of health care?
Well, I think we keep talking about that. We keep putting education out into the public. But this really highlights one of the most serious problems with what the court could potentially decide in their decision here, is they could have your boss, the owner of a corporation, be making decisions about medical science. Because that's what's happening here, is the owners of Hobby Lobby and Conestoga Wood Specialties are deciding what they think is abortion versus what they think is birth control. And they're not doctors. They're not scientists, and their decisions and their personal convictions should not be forced upon their employees. So this really points to one of the potentially harmful consequences.
Right. I mean, it's a suspension of disbelief, right? They're arguing that they are morally opposed to something where the science is unproven, that one should be basically morally opposed to those things based on the morals outlined. That is a really cumbersome way of explaining that this whole case effectively requires disbelieving actual science in and around Plan B.
That's
and
right.
there was a very chilling moment, actually, when Chief Justice Roberts, in fact, said the science doesn't matter. All that matters is that these bosses, these employers, believe that this is real, that these contraceptions might be, as they call them, abortion fashions, which medical science has said they're not. Justice Roberts was saying, doesn't matter what the science says. What matters is what these bosses believe, and that gives them provenance over what we as their employees can and cannot do.
Right, and Sandra, that's to your point. I mean, in terms of vaccines, one could say, well, I believe that vaccines create disease in young children, and therefore I am not covering vaccinations for my employees regardless of what science actually says.
Right. It could be a whole list of different healthcare treatments. There are certainly still folks who have religious-based objections to HIV or AIDS treatment or to mental health or blood transfusions, but it even goes beyond what types of healthcare services a corporation could deny its employees access to on health insurance. It also goes to the level of what other laws could a corporation say we don't need to comply with because our owners have a personal objection. We've already in the past seen corporate and owners of corporations saying that they had objections to a whole list of non-discrimination laws. We continue to see that stated regarding the LGBTQ community, but it's one of the main fights over the civil rights movement in the past, and we've seen cases where folks have said that their corporation should not have to pay women equal pay for equal work because they objected on religious grounds.
But Ilyse, you know, there's a whole flip side to this corporate personhood argument that corporate America seems well aware of, but that goes pretty under-discussed, which is once you open the door to corporate personhood and lift the corporate veil, as Brian Beutler outlines in Salon.com, you sort of open a Pandora's box of litigation, effectively. And corporate America seems to understand this and has sounded sort of neutral in this entire Supreme Court in these hearings, because they know if corporations are treated as people, then there's a whole host of litigatory activity that could then follow. It would seem like if there is a case to be made to the conservative justices on the Supreme Court, that would be it.
Well, absolutely, and we didn't talk about that, or we didn't hear much conversation about that in the context of the hearings today, although Brian did rightly point it out in Salon. And I think this is sort of the split we've seen all along, is that the corporations, who have certainly argued for personhood when it comes to political free speech, are really, they understand they're walking a delicate line. And if you cease to make any distinction between a CEO like David Green of Hobby Lobby and the corporate entity, that means that individuals who run companies can be liable in ways that they're protected from in terms of employees suing the corporation right now. And there's a real financial cost to that. By the way, this is also where we've seen dividing lines on this issue all along with insurance companies, right? Part of the reason insurance companies have traditionally covered contraception is because it is the best way to help women stay healthy and have intended pregnancies, which we know are the lowest risk pregnancies. And therefore, from a business perspective, offering contraception is a good business decision. So we're seeing that split here, where you've got sort of the zealots like David Green at Hobby Lobby saying, forget about all of that, my morals trump all of that, and I get to tell you what to do. And you've got other corporations going, not so fast.
Yeah.
We're not sure what this means.
Sandra, before we go, I mean, this breaking news banner here, this probably doesn't have that much to do, or as much to do, with religious freedom and a real moral objection to the contraception mandate in the ACA. This is a hugely political case, and you know, representative of that is the fact that 80 amicus briefs were filed on this, I believe, which is one of the highest tallies ever. 53% of the country does not believe employers should be exempted from the contraceptive mandate. But this case, and in particular Hobby Lobby, throws open the doors to repealing and replacing parts of the Affordable Care Act and undermining its effective solvency. And I think that, more than anything, is why it's gotten so much traction on the right. Would you agree?
Well, I think it's an important case because it has such severe implications for women's health care immediately, but really important legal ramifications. And yes, it's politicized, but this really is a potential major change to our constitutional law, and I believe damage to our religious liberty protections, because we've fought for a long time to have the right balance on those that protects individual religious liberty, along with protecting employees and the public and others' safety and health care. So this is an important constitutional moment as well, and that's part of why everyone's weighing in.
Ilyse Hogue and Sandra Fluke, thank you both. We will talk to you again in the coming weeks, my friends.
Thank you.
Thanks, Alex.